California's courts, California Appellate and Superior. The courts of appeal are made up of districts, as in 3rd, 5th, 6th, and 4th. They are made up of associate justices with one presiding judge, and their qualifications are the same as with the California Supreme Court. They were established in 1904 by California Constitutional Amendment, and the legislature has the authority to create new appellate districts if it wants to through its lawmaking powers. There are two ways of getting to the courts of appeal. Similarly, as with the California Supreme Court, jurisdiction can be gained by either original jurisdiction or appellate jurisdiction. Original jurisdiction, we have habeas corpus, mandamus, and prohibition. And appellate jurisdiction, we have certiorari, cases from the superior court level, and certain other cases prescribed by statute. Here's a map of the different districts in the courts of appeal. As we mentioned before, there are 6 different districts, and they're highlighted in the colors here. So you can see the bright blue 1st Appellate District, which is the California Northern Coastal area. That particular district has its headquarters in San Francisco. The 2nd Appellate District is in the south, and you're looking at the counties of Los Angeles, Ventura, Santa Barbara, and San Luis Obispo, and their seat in the Appellate District is in Los Angeles. The 3rd Appellate District, you're looking at the northern area of California, most of the north, and the foothills area also encompasses kind of the Sacramento-Yolo area all the way up to Modoc County. And this is going to have Sacramento as its seat for this particular district. The 4th Appellate District is the one down south. We're looking at Riverside, San Bernardino, San Diego counties, for example. Orange is in there and a few others. And we have San Diego as the seat for that for that district. The 5th Appellate District is in the Central County area. We have Tuolumne in there, Kings and Fresno, looks like Madera counties, and a couple other ones thrown in there in the central area, and Fresno is where we have the seat for the Appellate District. And then the 6th District has the San Francisco Bay Area, where we have, the 6th District, I'm looking at Monterey, has Monterey, Santa Cruz. It does have the Santa Clara County in there, which is why I said San Francisco Bay Area, but Santa Clara County is in there, and San Benito, and they have their district headquarters in San Jose. As you probably could have guessed by looking at this, it's broken up by population mostly, which is why you have a much larger area in that northeastern area over there. It's because the population up there is much, much more sparse than, say, the southwestern area of the 2nd Appellate District. The superior courts are the lowest level of court we have in the state court system. The legislature is going to determine the number of judges in each court, and so it can change according to the legislature's determination if new laws are enacted. In order to be a judge of the superior court, you must have been a member of the state bar or a judge of a California court for at least 10 years, immediately preceding your election or appointment. At the superior level, you can either be elected, which is the most popular way of doing this, or appointed by the governor. The appointments can only happen when there's a vacancy that happens during the term. Otherwise, all of the superior court judges are elected. So you'll likely see on your ballots when you go to vote in the general elections different superior court judges who are running for their judgeships, and you can elect them through that measure. They're elected by the county voters, and they serve 6-year terms. The superior courts have trial jurisdiction, which is why we call them the trial courts. So they have the fact-finding duties for all criminal and civil law cases. It's the very beginning where you start, where all the fact-finding is going to be done by the judges. Once you go above that level, you're really looking for procedural appeals, things that the lower court did wrong procedurally or did wrong administratively. However, all of the fact-finding is going to be done at this lowest court level. This is the course caseloads for 2011 and 2012, and this is straight off the California Courts website. You can look them up at courts.ca.gov. The Supreme Court within this year did 9,237 cases, and this is 9,237 filings, and this is for the fiscal year. Their decisions are published in the California Official Reports. So you can go into a law library, look up California Official Reports, and see their reported decisions. The Courts of Appeal in California had 21,894 filings. Only 8% of their decisions are published, however, and they're published in the California Appellate Reports. The California Appellate Reports are going to publish cases which establish a new rule of law, involve a legal issue of public interest, criticize existing law, or a significant contribution to legal literature. In other words, if they're making a decision which is much like a decision they made before, or which has already been proven as a standing point of law, it likely won't be published because it would be duplicative. The superior courts had almost 8.5 million filings, and that number of filings, of course, the largest because that's where everyone is going to start, and not all cases come up on appeal.